Well, welcome everybody to this very special event, a right of peoples and individuals to international solidarity. I'm pleased to welcome you all to this Johns Hopkins SAIS Faculty Research Forum, and I'm delighted to see so many of our faculty colleagues, as well as students, staff, and guests in attendance. This series is designed to showcase the path-breaking research of our SAIS colleagues in Washington, Bologna, and Nanjing. And I want to thank Vice Dean Jessica Fonzo for her commitment to this initiative. Today, I have the great pleasure to introduce Professor Obiora Okafor, the Edward B. Berling Chair in International Law, for this, his inaugural lecture at SAIS. His talk, which as I said, is entitled A Right of Peoples and Individuals to International Solidarity, analyzing its suitability, providence, character, and orientation, will explore the concept of international solidarity. It's a theory in which he is a world-renowned expert. And there's no more important time to address these issues of human rights and solidarity, as the COVID-19 pandemic has had a profound impact on human security around the globe. And COP26 has reminded us of our shared responsibility for the planet and each other. Prior to joining us here at SAIS, Professor Okafor taught international law at Osgoode Hall Law School at York University and at Carleton University, Ottawa, and the University of Nigeria. Since 2017, he served as the UN Independent Expert on Human Rights and International Solidarity, advising the UN Human Rights Council and the General Assembly. And he was a former chairperson of the United Nations Human Rights Council Advisory Committee. He's also served as an SSRC MacArthur Foundation visiting scholar at Harvard Law School's Human Rights Program, a Canada-US Fulbright Scholar at MIT, a visiting professor at the International Institute of Human Rights in Strasbourg, France, and he has published widely and has received many awards for his scholarship and teaching. We're also very fortunate to be joined today by Professor Cecilia Baillet, who will serve as the discussant. Professor Baillet is director of the Master's Program in International Law and co-director of the research group on human rights in conflict, peace, and security law at the University of Oslo. Professor Baillet researches transnational and cross-disciplinary issues of international law, including general public international law, human rights, refugee law, counterterrorism, and gender and women's rights and peace. Her most recent book is The Construction of the Customary Law of Peace, Latin America and the Inter-American Court of Human Rights. I have no doubt that this will be an important and stimulating discussion. And so without further ado, it's my pleasure to introduce to you Professor Obiora Okafor.
I'm muted. Thank you so much, Dean Steinberg. Thank you to Vice Dean Fanzo and all those who organized this inaugural lecture. If you don't mind, I'm just going to share my screen because I have a PowerPoint, and then we can begin. I can begin the presentation. So as Dean Steinberg has just said, the topic of my talk today is on a candidate right, a proposed international human right to international solidarity. And I want to analyze today just a part of that because of time constraints, a part of a longer argument in the paper, a very long paper on this topic. So I will not have time, that's a caveat, to get into the nitty-gritty of the specific version of that right that has been proposed in the draft UN Declaration on the right of peoples and individuals to international solidarity. I won't get into the nitty-gritty, but however, I will analyze its arguments for and against its suitability and so on. And you have before you here the outline of the presentation, how it will proceed. After some introductory remarks, I will look at the gravamen, as lawyers say, the kernel of the issue, which is the conception of international human rights that we have. And I will make an argument for greater epistemic openness in conceiving of what international human rights are or are not, what I refer to as human rightness, taking some liberties there with the language. And then I will then zero in on what I refer to as the contested suitability of international solidarity as a human right, and to proceed in the way that I've outlined. And then I'll end with some concluding remarks. Okay, so in February of 1996, at a lecture at Pace University in the US, then Judge of the European Court of Human Rights, Ronald St. John MacDonald, the great Canadian, firmly declared that solidarity is a fundamental and fundamentally sound principle, an emphasis on principle, of international law. Now, this claim or this position has become a near aphorism and has now become very widely dispersed and accepted as the solidarity is a fundamental principle of international law. There's really very little room at this point for reasonable disputation about that point. So I refer there, as you can see from the PowerPoint, to work by former Professor George Bruno Sima, Rudiger Wolfram, Samantha Bisson, Volker Turk, and Madeleine Garlick in the refugee context, international refugee context, and the work that the United Nations has done with human rights, migration, climate change, outer space, the law of the sea, and so on. But I want to focus on the current proposal at the UN Human Rights Council for the emergence of an international solidarity right, of international solidarity as a human right, not as a principle. It is one thing to accept that something is a principle of international law, and is another, of course, to accept that it is a right, a human right that particular right holders can claim vis-a-vis particular duty bearers. At the UN, most delegations at the UN, in fact, the vast majority of delegations support this proposal, but they are almost all from the global south. A minority does not support that proposal largely, and they're almost all from the global north. So the goal of my presentation today really is to explore and attempt to clarify certain issues, certain questions that I see as pertinent that concern the candidature of this proposed right to international solidarity as a human right. Now, the human rightness, if you like, of the proposed right is frequently conflated with its lawness. That is, whether it can become an enforceable legal claim in a court. But these are separate questions. They're of course connected, and we must keep this in mind here. We don't have time to get into the detail, but I refer you to Amartya Sen's germinal essay, Elements of a Theory of Human Rights, for example, among many others. I focus on the former question. That is the question of the human rightness of the proposed right to international solidarity, not necessarily on the question of whether it can be claimed in a court of law. Not being able to be claimed in a court of law says almost nothing about the qualification of something as a human right. Being able to be claiming in the court of law gives it a certain enforceability in the legal realm, but doesn't sort of define its human rightness, if you like, at least in my view, and in Sen's view. So in terms of the substance of the presentation, first, I offer a kind of lay of the land, non-comprehensive overview discussion that is meant to be indicative, just indicative of the different conceptions of human rightsness, and that my aim here is to show the lack of immanence, or if you like, givenness of ideas about what human rights are and are not over the long durée, over time. And then I discuss and respond to the main objections to the candidature of this proposed right. And then I'll follow that with an analysis, if I have time, but I anticipate I will not have time, of the details of the historical development, provenance, character, and so on, but I likely will not get to that because I only have very limited time today. And then I will end with some concluding remarks. To be clear, the overarching argument that I make today is not that the proposed right to solidarity or international solidarity is somehow immanently a human right, or that it is already accepted as such by every actor in the world, as much as it is that, given the conceptual and historical contingency of the demarcation of the boundaries of what human rights are and what human rights are not, the proposed right can become more fully accepted over the long durée as a human right than it already is. And it's actually, in my view, on its way. I wouldn't have time to defend this last bit of my claim today, but there is evidence in the longer paper that I wouldn't be able to speak entirely to. So I'm not suggesting here, just to be clear at the beginning as well, that the boundaries of human rightness are infinitely elastic, but rather it is actually an argument that the current borders of human rightness don't have to shift all that much, if at all, to accommodate the proposed right to international solidarity. So with that in mind, I now launch into my discussion of the conception over the long durée of international human rights, and emphasis on international. Of course, human rights praxis, be it national or international, is now way past Bentham's dismissal, really, of human rights as rhetorical nonsense and nonsense upon stilts. Human rights now sits atop dizzying height, what Makau Mutua once referred to as a high moral plateau. The dominant strain within human rights discourse has big L, liberal roots. So for instance, and Cranston is just one of many, Cranston argues that any claim, any candidate right that does not fit squarely within the liberal framework ought never be accepted as a human right. And this is the dominant approach, actually, whether be it among scholars, be it among practitioners, to what international human rights are or are not, or what they ought to be or become, or not become. So this begs the question then, what are human rights? How shall we know human rights when we see them? What, in other words, defines the human rightness or otherwise of a claim? To strict liberals like Cranston, big L liberals, I mean, human rights are merely, an emphasis on merely here, a 20th century name, just a style, for what was once referred to in Europe as natural rights. And so, to be a human right logically within that frame, a claim must fit this frame. And logically as well, to have a right is then to be allowed by your government or the state to do something. Okay, so it's a very tight sort of set of boundaries that is set up there. But many contemporary scholars, even liberals, even self-described liberals, will find this conception to be rather too narrow and too confining. For example, Griffin and the Sealers, I could get into more details, but I don't have time, limit human rights claims to being allowed by your own government. Sorry, do not limit human rights claims to being allowed by your own government, there's a typo there, to do something of paramount importance. That is negative rights, as lawyers often say. They don't limit it in that way, and yet they may not dispute the liberal tag. Jack Donnelly, who's also mostly a liberal human rights scholar, a famous one, has demonstrated the political and socio-economic contingency, and this is the key here in my argument, of what came to be accepted or rejected, what made it to the human rights movie, and what was left on the cutting floor. It was not about immanence, it was about politics more than immanence. And he did this by demonstrating in earlier eras, for example, post-industrial revolution, and before that, and then he also did that by looking at what happened actually at the UN, United Nations. Susan Walt's work, archival work, also demonstrates this in terms of the heavy influence of culture and religion, and negotiations around that in terms of what made it into the Universal Declaration on Human Rights and what did not. And so Upendra Bakshi and Mutua, in very long works that I don't have time to get into, convincingly also show us how contingent and incomplete the current dominant liberal conception of human rights is. Habermas reminds us of the specificity of that conception as a particular response to specific developments at a particular time in a particular part of the world. Amartya Sen, then going through all this in his famous essay, develops a rigorous and, in my view, much more valid idea or conception of human rights. And to qualify, the candidate right must satisfy two threshold conditions. The first being its special importance, and the second, its social influenceability. That is the extent to which it can be influenced by some other actor, the state, other individuals around you taking an interest in the matter. So the above is a kind of rough lay of the land overview, but sort of idea of how contingent, at least the literature sees the development of the conception of human rights, but it's instructive enough for our purposes. And so the overarching insight that at least I take from these liberals and non-liberals alike is that there is not as much immanence to human rightness as is all too often assumed or implied. And there's also no big L liberal litmus test, which must be passed by every candidate human right. Little wonder then that Dembu's literature survey has found that indeed the deliberative school, the school that looks upon human rights as claims that are accepted as such in the course of political negotiation and agreement, ultimately, even if the basis for such acceptance is some other naturalist idea or cultural idea and so on. But ultimately, they are agreed upon. And what is not agreed upon does not become human rights. Whatever is agreed upon becomes, and put in the human rights treaties, becomes human rights. And that this is fast replacing the big L liberal orthodoxy. What is more, if you look at official human rights praxis, the official register of that praxis over the relative longue durée, this argument is strongly finds strong support. So even a brief survey, for example, of the way in which economic and social rights came to be accepted, right, as human rights will show, will sort of support strongly this argument. This argument about the historical socio-political contingency of understandings of human rightness. And it's sort of, if you like, gradual, almost iterative transformation over time, over the course of history. And so using the story of how economic and social rights got into various treaties, you almost see almost in a video form the point that I've been trying to make. So for example, on the day it was adopted in 1950, the European Convention had virtually no economic and social rights in it. This is the reason in 1952, 61, and with revisions in 96, the European Social Charter and some other protocols were adopted to ameliorate this gap. So the conception of human rightness that informed those who drafted the European Convention 1950 changed over time to accommodate economic and social rights. It did not really accommodate it in 1950. The American Convention on Human Rights of 69, a later convention, then contained only one generally worded economic and social rights provision, which was later ameliorated as the discussion and understanding evolved by the additional protocol of San Salvador of 1988, but the African Charter of 1981, much later in time, contains both civil and political rights and economic and social rights. The conception of human rightness had altered over time, had shifted by this time, by 1981. So watch the dates. So the clarity came with time and struggle. It was not immanent. It certainly did not seem so to those who drafted the European Convention in 1950. So the youngest treaty of these three benefited from this alteration in the conception of human rightness. So to argue, as some have, that every new human right must look just like the human rights that were accepted before it, goes against the historical evidence I've just sort of developed for you, albeit in brief, in sketch. Excuse me. So the debate around, my key point then, or derived point would be that the debate around whether or not a right such as the proposed right to international solidarity will be accepted should be informed by this baseline fact. This baseline fact of the historical and socio-political contingency of the conception of human rightness itself. We must begin from that point. That is what should frame and shape the discussion, not the notion that people like Cranston, for example, had, that it has to fit a particular liberal straitjacket. So we then have to begin our analysis by being a bit more flexible, with a more flexible idea of what human rights are not, or what they can and cannot be. This is a call then for more epistemic openness and a call for a more globally sensitive conception of what human rights are and are not. As Mutua has taught us, the dominant strain in human rights thought is only one piece of the whole and only partially fills the gourd of human rights. And so did Philip Alston write decades now in the 80s in his famous paper on conjuring up new human rights, in the American Journal of International Law, 1984, that the philosophical foundations of international human rights and the basis for accepting or rejecting candidate rights can be found in a more diverse, pluralistic set of justifications and not merely one philosophy. As such, and if you like, given real world global diversity and the realities of the diversity of the global institutions that will accept or reject such candidate rights, applying one sort of stable, monolithic, unchanging list of substantive requirements as a litmus test for what human rightness is or is not will be rather unrealistic, in my view, at least on the global level. Now, again, this does not mean that we cannot have guardrails, right? It doesn't mean that we must have a completely open-ended idea or pathway to becoming, if you like, human rights. Alston offers such guardrails in his procedural approach, at least to the UN process, which is the main process these days, at least on the global plane, of assessing the suitability or otherwise of a candidate human right. Is of the view, and I agree, that before the ultimate decision is made in the General Assembly, where it is ultimately made, 4 things need to happen. The candidate right needs to be adopted through a process where input is obtained from a wide variety of sources around the world, and such inputs must address as many as possible of the substantive issues that he lists. We'll come to them later. And there needs to be several phases in the process of considering the proposal to adopt that right, so that there is greater reflection and so on. And it is desirable for experts, of course, to have input. Given that I agree with Alston's last point, I will not offer here a substantive definition as such. Safe to say that if I'm pressed, I will adopt Amartya Sen's threshold criteria of special importance to the globe and social influenceability. Rather, what I do is I adopt Alston's procedural approach, but not as a kind of litmus test or sole determinant, sole pathway to human rightness, but as one systematic way of showing that that particular candidate right with which I'm concerned today, the proposed international solidarity right, can become more widely accepted, at least at the UN, as a human right. So, but before I proceed further, it's important, again, I wouldn't have time to get into too much detail, but it's important to get some sense of the notion of international solidarity that we're working with here. So I'll take a brief look at that, but not before saying, relying on the scholars I've mentioned, that the concept of international solidarity has deep roots from really around the world in social, cultural, religious, and political systems of thought. Notably, the French Revolution, legislation from the 1700s, late 1700s, from the French National Assembly, for example, in Europe, and on the global plane, the work of Immanuel Kant, who looked at it not as charity, but as obligation, although political or moral obligation. Sorry. Now, sorry, a little mix up there. So my definition is relies on the one that the UN Human Rights Council uses. It's not perfect at all, but it will do for our purposes, and it's about expression of a spirit of unity among individuals, people, states, and international organizations. So it's multivalent and so on, encompassing the union of their interests, purposes, and actions in order to achieve common goals. Now, what are the objections that have been made by the strongest opponents, shall I say, and the most sort of those who have written it out most systematically, to the candidature of the proposed right to international solidarity, and how might one respond. The first one I've already started by almost offering a response to the first objection, and that is that the proposed right, the candidate right, is inherently, immanently unsuitable, right, as a human right. The key claim here is that it embodies an idea that is dissimilar to most existing human rights or existing human rights principles, and so cannot be recognized as such. As I've already dealt with this in my opener, the opening sort of minutes, so I will not, I will not let that detain us here, except to re-emphasize that the argument I've already made is that there is no such immanent conception of human rights that we can then test the candidate right against, or at least there is no such right that presents an insurmountable obstacle to it becoming more widely accepted. The second objection that has been raised, again quite thoughtfully by scholars like Hus Hannam, and I've actually had a one-on-one conversation with him about it, is the excessive vagueness objection. And I think this is the, if you like, the best case scenario for those who oppose the emergence of international solidarity as a human right. These scholars, like Hannam, argue, I don't know why this keeps flipping, argue that it is unrealistic to create a new right without knowing exactly what it means, right? This is the argument. And they say that this is not possible with the right to international solidarity because it suffers from a very high degree of ambiguity and generality. It's couched in a too general a fashion or a way. And this objection resonates with Alston's caution in his famous essay that to become acceptable, any new candidate right has to have a certain degree of concreteness, a certain degree of specificity in order to enable it to be operationally significant at whatever level, international or national level. This is not, of course, an unreasonable worry to have at all. The proposed right does indeed embrace a broad sort of concept, but that does not, if you like, solve the problem. That does not end the debate. Okay. Let's begin by reminding ourselves that as Scandinavian and American realism and critical legal studies have long taught us, all rights are more or less indeterminate. All rights are more or less indeterminate. So they carry with them a certain degree of ambiguity to begin with, to start with. But again, that does not mean that indeterminacy cannot be more or less intense. We recognize that indeterminacy can be more or less intense, and the sophisticated argument that Hannam has put forward is that the solidarity right would sort of tend toward greater indeterminacy than most other human rights claims. So the key question then is the indeterminacy of the proposed solidarity right, or the solidarity concept that it embodies, so excessive as to be disqualifying of its candidacy in this particular case? Is it so excessive? And the only way we can know is by looking at other existing, already accepted human rights, right? I must admit that it is, shall we say, more generally couched than, say, the right to freedom of expression. Doesn't mean the right to freedom of expression is without ambiguity, or the right to assemble or the right to food, and so on, which are already well accepted international human rights contained in the so-called International Bill of Rights. However, if you look carefully at the International Bill of Rights and look at all the rights that it contains, one thing stands out clearly. There is no single bandwidth within which all of them fall. There are much more specific rights. There are extremely vague rights as we speak today. So we don't have to disagree that the international solidarity right is somewhat more generally couched, to then disagree that it cannot become accepted as a human right. So when you actually look at existing rights contained in the International Bill of Rights that almost every country has subscribed to, and that these scholars endorse, you will see that there is no they don't all look alike in terms of their generality or specificity. For example, look at the fair trial right. At first glance, it seems like a very specific right. It is not. It's actually a composite right that contains a great many rights. Just take a look, if you can, at the International Covenant on Civil and Political Rights, a quite broad and all-encompassing right. It is much broader than the right to leave one's country, quite specific, narrower. The right to self-determination is notoriously general, right? But compared to the right not to be imprisoned for a contractual debt, much more specific. So, and lastly, in this respect, how specific really is the right to democracy that many of these scholars who make this objection agree is that it should be a human right. So my point here is not that the human right should not be as specifically couched as possible. That's not my point. Rather, my point is that a lack of a high degree of specificity has hardly been automatically disqualifying or fatal in terms of the actual evidence. When you look at the already actually existing human rights in the International Bill of Rights. So the reality is that it depends if a value is seen as extremely important, its specificity has not prevented it from gaining international acceptance in the past. That's what I'm trying to say. But leaving aside the argument that the international solidarity right is vaguely, generally couched, it may not, upon further examination, be entirely correct to even claim that it is excessively, and emphasis is on excessive here, general and vague in its framing. For just like the right to fair trial, or self-determination or democracy, its imprecision diminishes when you think of it as a composite right that consists of subsidiary or entailed rights that may or may not be necessary to realize it, depending on the context. For example, fair trial rights, if you are in a civil trial, it looks slightly different from if you are in a criminal trial, right? And there's many components to it that I can't get into today. The right to democracy is quite broad. It's a composite right. The right to vote, the right of minorities, and so on. There's many different facets. So what Carlson referred to as a dynamic process of concretization. As that right concretizes, it becomes more specific. Okay? So the current body of international human rights norms does not lack composite rights. Aspects, or if you like, dimensions of the proposed right to international solidarity are deployable, in my view, in certain specific areas and cases, and in specific enough ways as to be operationally significant. Take, for example, our current global circumstance, the COVID-19 pandemic. The right to international solidarity is deployable and has, in fact, been deployed in terms of access to COVID-19 vaccine context to require specific actions to be taken by very specific actors in order to benefit very specific persons halfway across the globe. Deployed an argument, that is. But the European Union has deployed the concept itself of international solidarity in order to exempt certain states, a list of, I think it was almost 60 states, from the vaccine export ban that it once issued in the regulation itself that it made. So it gives you an illustration of how a composite international right to solidarity could take on particular forms in particular contexts like COVID-19 vaccine. Secondly, this right has already been deployed in the French context, in a criminal trial for that matter, in order to set free a French farmer who provided aid and comfort to irregular migrants and who was charged criminally. It was deployed by a French constitutional court to set him free. And this is a Cedric Héroux case. So in specific contexts and specific cases, the meaning of the proposed right can be quite specific. Lastly, in terms of the objections, the lack of broad global support is one of the objections that some have offered. I think this is the least valid of the objections that have been offered. Those opposed to the proposed right tend to argue that for a candidate right to become accepted, it must attract broad international support. And this is not in principle a problematic requirement, in principle. The devil, though, is in the details. What does broad support really mean at the UN? And how does such support, how broad does such support have to be? It is difficult to accept the argument that a proposition supported by the vast majority of states, and more importantly, by a collection of states in which 90% of the people who would benefit from such a right, everyone would benefit, but 90% of everyone lives in those states. It does not enjoy broad international support, especially at the level of the UN. Now, having considered the objections and responded to them, I want to very quickly apply Alston's procedural test, which initially I had made a case for adopting. And my argument in the end is that if you apply that test, you find, again, in a systematic way, going through that test systematically, that the candidate's right can become, again, I'm not saying that it will be necessarily, that is left to political negotiation at the UN, but can become generally accepted as a human right. Excuse me. So the first criteria, which I've already mentioned, was whether inputs were obtained from a wide variety of sources. Yes, several times over, and I can give details in discussion. But the second requirement of whether certain of the substantive issues that he refers to and lists were attended to, or were responded to, well responded to. I want to speak to that before moving toward a conclusion. Let me go down the list. The first is that the proposed right reflects a fundamentally important social value, and that was the first substantive criteria, and this kind of aligns with Sen's definition. Being an important global social value is important, and international solidarity, at least the pandemic has reminded us, is not the only thing that reminds us of that, but has reminded us of how important international solidarity is. The second point I want to make is in response or in developing going through that test, is that the right is definitely relevant to the entire globe, even in its diversity. The right is also clearly eligible for recognition as an interpretation of the UN Charter. I began by citing George Ron St. John MacDonald, saying that this is a fundamental principle of international law. The right, as we have already argued, is also consistent. It's not inconsistent with the existing body of international human rights law. And it has also, it has already achieved, or this is capable of achieving a high degree of international consensus. Consensus does not mean unanimity at the UN. And then it is also not incompatible with the general practice of states because it is consistent with a fundamental value, which is the principle of international solidarity. Then I think it is precise enough, keyword here is enough, or rather, it is not too vague as to give rise to identifiable rights and obligations. And then were there several phases in the process to, process of trying to attempt to adopt it? Yes, the answer is yes, sorry. Was there expert input? Yes, extensively. Has the UN General Assembly voted? No, not yet. That which is why it's still a candidate right. So what the foregoing analysis indicates, at least to me, is that there's very little to nothing that prevents the proposed right to international solidarity from eventually meeting every single one of Alston's procedural requirements and its entailed substantive preferences, and that this supports my overarching argument that the proposed right can become adopted as a human right. And then lastly, for those who would argue too forcefully that the proposed right to international solidarity is unlikely to be ever adopted at the UN, may I remind them kindly that the binding international treaty on the right to development, which is an instantiation of the solidarity principle, is currently being negotiated in Geneva under the auspices of Human Rights Council's Working Group on the Right to Development. This development of the right to development would have shocked the renowned Senegalese jurists Doudou Thiam and Keba Mbaye in the 70s and 80s when they first innovated and championed the idea of a right to development. The progress from their perspective that has been made would have shocked them. And so my view is that while it is clearly not yet uhuru, we're not there yet, not yet success for the proposed right of peoples and individuals to international solidarity, it is certainly too soon to sing its non-dimittis. I thank you all very much for your attention. It's been a great honor. Okay.
Yes, my warmest thanks to Professor Okafor and the Johns Hopkins School of International Studies for inviting me to have the honor of serving as discussant to the UN experts' most innovative inaugural lecture. Professor Okafor offers a call for reflection and engagement in addressing the creative epoch we are in terms of the exciting evolution of human rights law. He calls for a new, open-minded, globally sensitive, and globally relevant understanding of human rights. He identifies a contextually grounded human right imaginary, recognized within the human rights instruments and literature from Africa, Asia, and Latin America that comprise 90% of the world population, and that include a more complete approach to human rights, precisely because they recognize duties and collective or group rights, as well as third generation or future generation rights as part of the elements of human dignity. And this is in keeping with Mutua's call for completeness in human rights, or alternatively, which Rosa Friedman calls as the second wave of third generation rights that also include the right to peace, recognized as a declaration by the UN General Assembly, the right to development, which the UN expert mentioned is being elaborated into a convention, and the right to a healthy environment recognized by the Human Rights Council. Professor Okafor cites Amartya Sen. For a freedom to amount to a human right, it must be important enough to justify requiring individuals to pay substantive attention to determine what they can reasonably do to advance it. And this is precisely the characteristic which is most exciting. Can we interpret the right to solidarity as prompting a consciousness about the interconnectedness of peoples as well as the environment, and recognition of our, meaning individuals and peoples, ability and responsibility to engage and cooperate with each other to address transnational common challenges like climate change, pandemics, inequality, and protection of refugees and asylum seekers? One may suggest that solidarity could be regarded as a freedom or an emancipatory right related to action, such as freedom of expression or association or assembly. And furthermore, Professor Okafor recognizes that solidarity is a composite right that consists of entailed rights, just like the right to fair trial, self-determination, and democracy. And he says that this means that it has a potential for creative interpretation and implementation in context. He presents the Global South as offering a different human rights imaginary, which deemed international solidarity as a value of paramount concern to humanity as a whole, as a vital component of the efforts of developing countries towards the realization of the right of development of their peoples and the promotion of the full enjoyment of economic, social, and cultural rights by everyone. So in relation to the draft declaration, Professor Okafor, you actually query in your article who, in more exact terms, are the solidarity rights holders and duty bearers. And I'm wondering whether this would not be linked to Professor Karen O'Brien's proposal in her book, You Matter More Than You Think, calling for a so-called quantum social change to tackle global crises based on the simple act of recognition of our interconnectedness. Hence, everyone matters, and thus all individuals and peoples would be both right holders and duty bearers. And Professor Okafor, you cite Kant's observation that the human community shares the surface of the same earth, so all individuals must support each other. And this is similar to the notion raised by O'Brien, citing Graham Hansen, of the obligation to live up to the responsibilities involved when taking part in a relationship, be it to other humans, other species, the land, or the climate. Hence, solidarity may be viewed as a call to depart from the binary orientation of us versus them and move towards recognition that the subjective quality of analysis is derived precisely from the relationship or the connection between individuals and peoples and non-humans that are linked through processes. Hence, we may propose that for solidarity, rather than talk of rights, we would talk about responsibilities or right relations. And as O'Brien remarks, when we disregard or overlook the collective transpersonal nature of human existence, we underestimate our individual and shared potential for generating social change. So Professor Okafor, my first question to you is, cannot all states, individuals, and peoples, potentially even IOs and NGOs, communities, or trade unions, be both right holders and duty bearers?
Thank you so much, first of all, Professor Baye, for chairing the occasion, for being a discussant, and for your question, and also for your work, extensive work that I'm privy to, hopefully coming out soon on solidarity, international solidarity at the Human Rights Council. In terms of the right holders, I know I didn't have time to canvass the entire paper because of time. I was very conscious of time when I was gonna hiving off parts of it for this presentation. Yes, the thing with the way in which the solidarity right is being conceptualized, at least has been conceptualized in the draft declaration, is that, you know, it's not state-centric. I think there's already a question that connects to that in the Q&A that alludes to that. It's not state-centric. Duty bearers, states have, of course, continued to have the obligation to realize human rights, to protect human rights, including the right to development, but other actors, multinational corporations, other entities as well, that to the extent, and here I would refer actually to Sen's concept of perfect and imperfect obligations, to the extent that what they do, right, is a proximate cause. I think about, for example, global value chains now. You know, 30 years ago, nobody talked about global value chains as a kind of a chain of human rights responsibility, right? So to the extent that what they do would impact someone else, for example, to make it concrete, think about pharmaceutical companies and COVID vaccines. Pfizer's just come out and said, is it Pfizer? I think Pfizer-BioNTech has come out a few days ago saying we will license. I think it's a bit late, but it's still helpful. We will license to some countries, 70 or so countries, vaccines. What they do matters, right? In that kind of solidarity chain, assuming this was a human right. So they would have an obligation to respect human rights as well. So it depends on where they stand in relation to other actors. That would inform the nature of their obligations.
Thank you. So moving in a different direction then, at present, Mark Leonard proposes that we are in an age of unpeace, in which, ironically, it's precisely our connectivity to each other that actually increases the risk of conflict through weaponization of trade sanctions or blockage of supply chains, manipulation of the internet through fake news and disinformation, politically instrumentalized migration flows, climate change protectionism, and inequitable pandemic policies. And that these may be strategies used by traditionally weaker states against powerful ones. So how do we prevent solidarity from being interpreted in an exclusive manner to sustain national, nativist, or intragroup segregated community orientations to the detriment of other groups? So specifically, Carol Gould would call this a problem of unitary solidarity, which we saw demonstrated at the Polish border recently when migrants were weaponized by Belarus, were not allowed to enter due to the interest in preserving regional security prerogatives, thereby defending European solidarity expressed through the maintenance of border. Could you comment on that?
That's an extremely interesting question. And I don't want to sound like a broken record, kind of, but I think that the response actually, at least the seeds of my response we already offered in the presentation itself, which is that I think that the broader conceptual point is around indeterminacy of right, the ability for both sides of an issue to use precisely the same right to advance their claims, right? So we see that with every human right. I'll give you an example. Those who marched in Cairo during the Arab Spring, you know, Tahrir Square, defended their right to peaceful assembly and freedom of expression, right? Those who invaded the US Congress on January 6th this year, we're also claiming the right to assembly, right? And freedom of expression. So does the Ku Klux Klan. So do all kinds of extremely harmful forces, mobilized particularly on freedom of expression and their human rights and all that. So as critical legal studies has long told us, we have to go beyond the assertion of human rights claims to look at the values that are sought to be defended, right? And that is no different with the solidarity right. The same thing for freedom of expression or an assembly is the same thing for the solidarity right. Just because someone asserts solidarity does not mean that the value they want to defend. If you read the debate between Bartolomé de las Casas and Francisco de la Victoria, when the Spanish were debating in the court of Spain about what to do with the newly, quote unquote, encountered Indians, natives of the Americas, right? You see the seeds of the same indeterminacy, this idea that, well, we have to show solidarity, they are human just like us, but that also means that we have to conquer them and protect them. So this is the 1600s. The world has, this sort of arguing with rights and arguing with law from both all sides of political perspective or position, right? Is not unique to international solidarity. And I think I'll just offer a frame for dealing with that issue. Thank you.
Yeah, and it gets me thinking that when we move it away from law and towards this notion of common values, you in your article state that as the human community shares the surface of the same earth, all individuals must support each other. And so solidarity is a transnational obligation. And you cite the African Charter that actually requires every individual to have duties to the international community and also to strengthen social and national solidarity. And I feel like the context we're in right now is that we have a challenge where actually, ironically, it might be easier for people to demonstrate effective solidarity for persons subject to oppression far away in other nations than to exhibit empathy for other groups within their own nations due to political polarization, class divisions, religious antipathies, modern versus traditional values, and racism. And so I feel like we have a crisis of a complete lack of common values, even within nation states. How do we create agency for solidarity within fragmented, exclusionary, or hierarchical communities that fail to recognize that their polarizing actions lead to violence or destruction of nature or violations of human rights?
Yeah, it's a difficult one, which is why we must continue to think about it and sort of engage it. I think that in a sense, there's a sense in which precisely that is what the right to solidarity, at least the values behind it, aims to address, right? It asserts a form of global citizenship that not papers over, but that almost elides over or jumps over these divisions, right? And gets to our common humanity, because we do have common humanity. It is just the ways in which it is mobilized, right, as a resource for various particular projects. That is the issue. So internally, it is the same thing, right? I think that for example, when we realize that the reason I wear a mask is not to protect me, but is to protect you, and the reason you wear one is to protect me, right? Yeah. The debate around masking changes a slightly bit. It doesn't mean it's going to convince everybody, but it's not just you wearing a mask to protect yourself, it's actually to protect. So if we both don't wear masks in solidarity, neither of us is well protected, right? And I think that's a very good point. So the solidarity, proposed solidarity right has this capacity to remind us, right, continually of our communal situatedness, to remind us of that value of common humanity. And I think that's part of its strength. Of course, it has dangers, right? Like every right. I've just given the example of the dangers of freedom of expression being manipulated by hateful forces all the time. The law of freedom of expression, the law of free assembly, and they shouldn't be denied it. But the point is, it provides aid and comfort to them. I mean, Bakshi has sort of killed a lot of trees making this point in several papers and books, that both the politics of domination and the politics of progress, right, seek to harness the same texts, the same bodies of norms, the same rights claims, right? And it's a competition for these resources that is occurring. And so I think that, of course, it is, at the end of the day, a political, it has to be, you have to defer to politics, not necessarily in terms of what the text says, but it is actually small p politics, on the ground politics, in order to, so to speak, heal those divisions. But Solidarity Right provides a resource that we can mobilize. Yeah.
Yes. I want to raise an issue that you have in your paper that you didn't mention in the presentation, but I found it absolutely fascinating. You actually pointed out that those who argue against the right to solidarity are actually in favor of the recognition of the responsibility to protect doctrine. And R2P is the call to protect people from genocide, war crimes, ethnic cleansing, and crimes against humanity. And you cite Laurence Boisson de Chazon, querying, is the right to international solidarity the converse of the responsibility to protect, or is it implied by it? Mm-hmm. If powerful states have a responsibility to protect individuals or peoples who live in other countries from gross rights violations, do the weaker peoples have a right to such protection under such circumstances? And if they do, is it actually a right of international solidarity? And I'm wondering, can clarify this, because I think at the present time, the responsibility to protect apparatus appears to have evolved to emphasize the first pillar on prevention and creates a sequence of actions beginning with negotiation, peaceful conflict resolution, cooperation approaches before even considering military intervention as a last resort, and then only subject to authorization by the Security Council. So I assume that solidarity actually address those harms not covered by R2P, such as climate change, pandemics, that don't come under the R2P framework, and that I thought maybe solidarity would instead be a gap filler given the limitations of our R2P not applying to those situations which also endanger human life gravely. Could you comment on that?
Mm-hmm. I agree with what you're saying in terms of the way in which at least it's been framed at the Human Rights Council so far. When people are talking about rights, they're not talking about R2P, right? But what I was referring to is that if you dig deep into the underlying idea of both the right to international solidarity and the responsibility to protect, the conception of global citizenship that undergirds both of them is similarly dense, right? It assumes a kind of density of relationships, right? A kind of global neighborhood, right? Which then gives right to an obligation to almost protect your neighbor, right? So the conceptions are similar in both cases, but you have these sort of musical chairs at the UN. So when R2P is mentioned, the very countries that vote against the right to solidarity enthusiastically support the responsibility to protect, right? But and the countries that support the responsibility, the solidarity right, the proposed solidarity right, vote against it because they will be the object of intervention, right? And then it flips in each case, right? And that's what I was referring to. And again, this is my point about human rights being resources, right? That political agents, that agents deploy or mobilize in order to achieve particular values. So the only way to explain that behavior is that there are particular values that want to be achieved. They may not be good or bad values, but they're values, right? So the right the international solidarity right, for example, in a COVID-19 context, or to protect people like Cédric Héroux in France, and all that goes to certain humanitarian values, right? In the COVID-19 access to vaccine context, people are dying from this plague, really, and you want to achieve that. You want to get them vaccinated. Of course, benefits everybody because mutations over there can quickly, as we've seen with Delta, quickly become a problem here, even to the vaccinated, right? But I just was kind of intrigued by this flipping that occurs, right? When, if you like, different manifestations of international solidarity, at least of the underlying ethic, are presented at the UN, and leaves one wondering, well, it's not the resource that is at issue, it's something else, it's politics, right? Yeah.
Lovely. Okay, well, I think it's now time for us to turn for questions from the audience. So everyone in the audience, you are more than welcome to place your questions in the Q&A. And we already have one from Adam Webb, which I'm happy to read to you, Professor Okafor.
Okay.
Adam asks, much of the logic of UN rights discourse and the desire to recognize multiple cultural inputs to it hinges on a container society view of the nation state, or at least cultural collectivities. In other words, many individual claims to respect are seen in a post-liberal or non-liberal terms as embedded in collectivities or cultural relativism when it comes to the unit of analysis. Yet so much of the real rather than the merely symbolic work of human solidarity takes place in circuits of global civil society that confidently transcend those collectivities and disrupt suffocating claims on their members. So his question is there an inherent tension here? How can solidarity meaningfully escape its misuses by nation states if one relies on such well-worn UN-style frames of diversity and solidarity?
Mm-hmm. Thank you so much, Adam, for your question, which is an important one. I hate to be a downer of a sort, but it will be a long time before we escape the misuses of human rights as resources, be it solidarity or any other human right, right? They will continue to be misused. The history of human rights is replete with those instantiations. I started from 1600, to narrate it. So there's never been a time, any epoch, any era, when this has not happened. So it will continue to happen. We will not be able to escape it. What we can do is to continue to mobilize these resources, human rights, in order to struggle for our conception of the good life, in the conception of a better world, right? And part of that is to say, is there a concept or a right that does a certain job, that does work, that is significant toward attaining that conception of the good life? If, for example, we don't want half of the world outside our world to die of COVID-19, right? Is there a right, for example, or a resource that can do some work toward that objective? And my argument today, I didn't get to this part, is that it can't do work. Law and rights narrow the field of argument, right? If you look at, for example, because I like to be very specific, if you look at the EU export control, vaccine export control regulation, right? Because you already, even at the level of principle, the EU felt obligated to exempt about 60, I think, countries from that vaccine export ban, explicitly based on the principle of solidarity. Now, so the point is, if you already have the principle of solidarity, why do you need a right, right? Why do you need to have a right to do this? You need a right because a right does a work that a broad principle cannot do, right? A right is an affirmative claim that, again, narrows the maneuverability of the relevant actors, right? You have a demand on their resources that you would not otherwise have if you had just had a broad principle in a very more specific, more concrete way. And that's what the kind of job that a right will do. I understand the point about misuse, but I don't think that if we dwelt on that, we would have almost any human right in the International Bill of Rights. Thank you.
Very nice. Now we have a question from Tom Tearing. He asks if you compare a right to solidarity to the right to democracy. In your lecture, you posed the rhetorical question, when, if ever, a political party can be banned. And he gives one concrete example from Germany. On the 23rd of October in 1952, the German Constitutional Court banned, thereby declaring unconstitutional, the so-called Socialistic Reich Party. Based on Article 21(2) of the German Constitution, parties that by reason of their aims or behavior of their adherents seek to undermine or abolish the free democratic basic order or to endanger the existence of the Federal Republic of Germany shall be constitutional. A similar approach was used when the Communist Party of Germany was declared unconstitutional on 17 August 1956. So arguably, there's a level of precision concerning the right to democracy available at least on the national level. Do you see a similar level or even higher level of precision on the horizon for a right to solidarity, and would it more?
Yes, thank you, Tom. Unfortunately, Tom, I have to disagree with you. I think that the law about banning political parties, and I didn't have time in the paper, I provide the Turkish cases at the European Court. If you read those cases, you'll see that even the court doesn't know when you can ban political parties. Basically, they tell us it depends on the context, right? Perhaps the German context led the Constitutional Court to make those bans, but I can see very powerful arguments to the contrary. That banning one party because you don't like it, as long as they're not violent, for instance, would be anti-democratic, right? And that talk about misuse, that would be immediately misused by a lot of governments around the world if you had to export that. At least with the Turkish cases, the Turkish line of cases at European Court, the European Court, it's very ambiguous. It doesn't tell us precisely when or not a ban is sort of legitimate, right? Under the European Convention. So I'm not sure I agree with that. But to your other point about precision, I already give a very precise instance of precise application of that right, or possibility of a precise application in the context of COVID-19 vaccines. I'll give an example in the context of the persecution and even criminalization of those who provide aid and comfort to regular migrants in Europe. I cited the French Constitutional Court. This is a court, it's not a political forum, applying a principle of solidarity, which they derived from the French principle of fraternité, in order to set Mr. Heroux free, who would otherwise be sitting in jail as we speak. And he won that case on appeal to the French Constitutional Court. So I think it is definitely capable of at least as precise an application in particular contexts as the right to democracy, which is a very vague composite right. It's not one, it's not very precise in itself. It is a composite of the right to vote, the right to form a political party or not form one, the rights of minorities. It has many, many, many facets to it. That was my point. Thank you.
Okay, now we have another question from John Markey. He's asking, do you think the right to international solidarity, if it ever becomes a right, might suffer the same fate as the right to development, at least from a third world perspective?
Yes, thank you very much, my friend John Mark, who's a professor in South Africa. I would like to know what fate you think the right to development is. Because it has suffered many fates. One of it is good, which is a binding treaty is being negotiated at this moment. So that's one fate. Is the fate its continued opposition by richer states? Is that what you have in mind? If that's what you have in mind, Joe Mark, well, my answer would be yes, it might continue to be opposed, but I didn't want to get into my work as an independent expert because I don't want to get it mixed up the two hats that I'm wearing. I'm not presenting this as the independent expert on human rights. I was once asked, of course you have to defend. I said no. Perhaps I had this view before I was appointed independent expert, and they're writing. So it's not because I was made independent expert that I'm making this. So I don't want to get into that, but I just want to allude that as we speak, the draft declaration is being applied by a certain somebody in fact-finding missions, okay, to countries, including countries who don't support it, and assessing their behavior on that and issuing country reports which have been adopted. So it's being applied as we speak. It's not as sort of high-fi, airy-fairy as it might seem. So yes, there will continue to be opposition, but that is what negotiation is. Over time, states that didn't accept economic and social rights accept it more. Almost every country accepts it now. It wasn't always the case, and I gave that historical sketch to tell you how that became accepted. So it could get accepted. I don't know. I don't have a crystal ball, but who knows what fate, what other fate might befall it. Thank you, John.
Now we have a question from Goodwin Za. He says, great presentation. My question is, you suggested epistemic openness as the way to approach this new right development. And in doing this, you dismantled the classical narrow ideas on rights. That is good. But how do we establish epistemic openness in a world of constant contestation of ideas, where some ideas are often aligned to strong manifestation of power politics, which frames some ideas as superior, dominant, or stronger than some other ideas? Kindly shed some light on the counterpositions that can be marshaled to achieve this balance in epistemic openness. Thank you.
Well, I think that part of a scholar's job is to respond in a systematic way to the claims that I responded, and that's what I tried to do. Because the idea is, if the claim is that this is inconsistent, is somehow immanently unsuitable, let's take a look and see, is it really immanently unsuitable, right? And that's what I've tried to do, to take these arguments seriously. And that's all that we can do, Godwin. Take the arguments seriously and look at the evidence, the actual evidence, and see, does the evidence suggest that they're immanently unsuitable or not? If one is able to show, as I think I've done in the paper, that it is not immanently unsuitable, and by the way, it's not revolutionary. Philip Alston was making that argument about the right to development in the 1984 in the American Journal of International Law, for that matter, then I'm not suggesting I'm the heir to Austin or anything like that, but just a joke. You know, then we open up that epistemic space. That's what I was talking about. Then to begin from a perspective that is not extremely confining, to begin from a perspective that has a little more room for debate, right? A little more room for, shall we say, for change, and a little more flexibility, you know, for other candidates' rights that take this form. That's what I was trying to do. I don't envisage a world that is evacuated of power, in which there is no power relations, right? I can't really see that. So what you point out will continue to happen, but as a scholar, one must continue to play one's role, which is to debate and respond to arguments, take them seriously in a systematic way. Thank you. Yeah.
Well, I think we're coming to a close here. Unless if this is your last opportunity, if anybody would like to post a final question, you're welcome to do so now. If not, I will round off. Yeah. Okay, this has been an absolutely fascinating session. So again, I congratulate the university for giving you the chair, which is so greatly deserved, and the students will benefit so highly from your reflective creativity at approaching these legal issues, especially in this time of flux that we're in. I think the epistemic openness is something that we all carry the obligation to try and bring about. I think that the enthusiasm has to come from all of us, the academics, civil society, to create those spaces to ensure that the development of a recognition of a truly global understanding of human rights comes to fruition, and that we shouldn't be cynical or pessimistic. I think that, like was pointed out in the beginning, we have made tremendous progress with many of the other related rights. So there's nothing to stop us in relation to solidarity. And I, for one, am very optimistic. So a warm congratulations to you, Professor Okafor.
Thank you.
Would you like to say any final words?
Just to thank Dean Steinberg for personally opening the session, and to thank you so much, Cecilia, for all the work that you do to advance scholarship in these areas, and for the work that you continue to do on international solidarity, and to thank colleagues at SAIS and friends and everyone in the audience for lending me your ears today, so to speak. Thank you so much.
You have received warm congratulations from your colleagues. James Gaffey writes a wonderful inaugural lecture. Congratulations to being appointed to this chair. And Sylvia Bawa writes, excellent presentation. Thank you and congratulations.
Thank you so much.